Welcome back to Fox and Friends. A judge clears the 3 officers involved in that shooting that killed Sean Bell the night before his wedding. The judge now saying the prosecution's witnesses weren't credible enough. So why was a judge deciding the fate of these 3 men instead of a jury? And how it will affect the continued controversy over this case.
A guest on this controversial case is criminal defense attorney Remi Spencer, who joins us now. Remi, welcome. I mean, it really is a tragedy. You have Sean Bell. He's going to get married. They're at a strip club, and they're undercover officers in the strip club who think they hear that someone has a gun. They go outside, and there's like a confrontation. Bell's in the car, and 50 shots. And a judge acquitted the police detectives on this. Was this correct?
You know, you're absolutely right. This was a tragic event. No one is going to dispute that. Even in the judge's opinion, it's clear this is a sad, tragic event. But whether or not these officers are criminally responsible for their conduct that night is the real question. And the judge here said no. And I think the judge was right. And I'll tell you why. The officers explained that they had a reasonable belief that they were in danger or that a criminal act was about to take place. Did they believe that these individuals had guns on them that night?
But is that enough? You know, we hear that all the time in police shootings where the detectives and the officers say, we thought he had a gun. And there was no gun. And so very oftentimes they are acquitted. But honestly, is that fair? You're talking about 50 shots. 50. We want our police officers to be trained better than that.
Well, you're right. But I think there are 2 questions here. One, the touchstone to the police officer's conduct is reasonableness. Were they reasonable in their actions? That is, to believe that they had a gun. And if so, what was the proper course of action for them to take? And they're trained. Their standard operating procedures are to take down the threat, to avoid a threat. And here we know from the evidence at trial that this incident took place over just a couple of seconds. And there were several officers firing. So we have to get away from I think we should get away from the number of shots as to why the officers reacted the way they did.
I want to get back to the legal side of this because it's interesting. I think a lot of people wondering why in the world, first of all, was a jury not listening to this trial and a judge making the decision in this case? This seemed unprecedented.
You're right. This is a really interesting part of the case, especially from a lawyer's point of view, because as a defense attorney, we usually need the members of our community, the jurors, to listen, and we hope that they may become emotional about the case and care about our clients. But here, what happened was the defense asked to give up their constitutional right to have a jury of their peers and instead have their fate determined by a single person, the judge.
And it seems to me it sort of flies in the face. I sat on a pretty high-profile case at one point, and you had 12 people who were very clear-headed about a case. I know you're trying to not be emotionally involved in a case like this, but at the end of the day, aren't 12 heads better than 1?
Well, it's up to the defendant to decide if he thinks or she thinks that 12 heads are better than 1. And typically, a defendant will only give up that constitutional right to have a jury decide his or her innocence when they're pretty confident that either they have the law on their side or they're confident that the judge understands this case in a way that it will benefit them. And I think here that's exactly what we had, because whether or not the police officers were justified in their actions is really a question of law. And could 12 people from the community hear the evidence come out at trial and set aside the number of shots that were actually fired? Or would they be overcome with their emotions and think, it doesn't matter, something here must have been wrong, and we're going to ignore the charge of law? I think the defense was very, very smart in choosing to have a judge make a decision of law.
So bottom line, if you have a very emotional case, it obviously can work in a defendant's favor to have a judge who stays on the law and not on the emotion.
Yes, because, you know, typically a defendant loses at trial. If a prosecutor is bringing their case to trial, they should win it. Otherwise, they would have pled it out earlier in the litigation. So if they're going to trial, they should win. And the defendant is likely to lose. And usually we need the jurors to become emotional and care about the defendant. But here, it's exactly the opposite.
And look for a civil trial next, I'm sure. Remi Spencer, criminal defense attorney, we appreciate your views this morning.
Thanks
for coming in.
Well, kids, you get a legal lesson like you won't believe. You know what they're doing in class now? Watching DWI defendants walk right by. We'll tell you about that.
We'll be right back.